Ladies and gentlemen, if you will please, I would ask that you give me your careful attention for the next few minutes in order that I may instruct you with regard to the law in this case. In order for you to make a just and lawful decision, it is necessary for you not only to understand the evidence in the case, but also that you understand the law and apply it to the evidence as you may find it to be. Before explaining the status upon which the indictment is based, let me explain certain of the terms contained in the indictment. You will notice when you received a copy of the indictment that it charges the defendants acted unlawfully, that they acted willfully, and that they acted knowingly. I will define those terms for you as they are used in the indictment. The word unlawfully means contrary to law. To act unlawfully means to do something willfully which is contrary to law. The word willfully, as used in the indictment, means that an act is done purposely with the specific intent to do that which the law forbids. That is to say, with bad purpose, either to disobey or disregard the law. The indictment also charges each of these defendants with having acted knowingly. The purpose of adding that word was to ensure that no one would be convicted of an act that was done because of a mistake or any other innocent reason. A copy of the indictment will be provided to you and is not to be considered by you as evidence in this case. Each defendant has pled not guilty to the charges. Therefore, you will want to base your verdict upon the evidence in the case. In a criminal case, the jury is the exclusive judges of the facts, the credibility of the witnesses, and the weight that should be accorded to the testimony of the various witnesses. You will want to try this case upon the evidence that has been admitted for your consideration. Although you are the sole judges of the facts in the case, it is your duty to accept the law as given to you by the court and to apply that law to the facts as you may find them to be. You will want to take all of the evidence produced in this case by the government and by the defendants and give it full, fair, and impartial consideration. If you find there are any conflicts in the statements of any of the witnesses, you will want to try to reconcile them if you can without arriving at a decision that any witness has sworn falsely, because the law presumes that every witness is attempting to tell the truth. In forming your opinion as to the weight and credibility to be given to the testimony of the witnesses, you should take into consideration a number of factors. Look at the general character of the witness, his intelligence, his ability to speak the truth, and in that way determine what weight and credibility you think should be accorded to the testimony of the various witnesses. The law presumes the defendant to be innocent of the crime with which he is charged. That means that the government, therefore, must prove the guilt of the defendant, and the defendant is not required to prove his innocence. Every defendant starts out in a criminal trial with this presumption of innocence in his favor, and that should be borne in mind by you throughout your deliberations in the case. The presumption of innocence alone is sufficient to entitle the defendant to a verdict of acquittal unless or until the jury is satisfied beyond a reasonable doubt that from all of the evidence in the case as to the defendant's guilt. A reasonable doubt is just what those two words mean in our ordinary language. A reasonable doubt is a fair doubt. It is a doubt based upon reason and common sense and arising out of the state of evidence in the case. Proof beyond a reasonable doubt is established if the evidence is such that you would be willing to rely upon it and act upon it in the most important affairs of your life. A reasonable doubt may arise in a case not only from the evidence produced, but also from a lack of evidence, should you find there to be any lack of such evidence. Since the burden is upon the government to prove the accused guilty beyond a reasonable doubt of every essential element of the offense charged, then the defendant has the right to rely upon the failure of the government to establish such proof. The law does not impose upon the defendant the duty of producing any evidence. The defendant who wishes to testify, however, is a competent witness in the case, and you would want to test his testimony the same as the testimony of the other witnesses. You should apply the same test, in other words, in judging his credibility, that you would apply in judging the credibility of the other witnesses in the trial. On the other hand, the law does not compel a defendant in a criminal case to take the witness stand to testify, and no presumption of guilt may be raised, and no inference of any kind may be drawn from the failure of any defendant to testify. That was pretty snappy. How's it?
Yeah, snappy.